Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the June 2026 edition of the Third Fridays podcast. I am your host, Christian Cison, and usually we start off the show by recapping last month's episode. We will certainly do that, but I thought we'd take stock of what has happened this year so far. In June, everybody's making their summer plans or excited for their summer vacations. The weather's starting to turn. The days are getting longer. The sun is up earlier and down later. And it's always a very exciting time here in the Northeast. And me personally, especially as maybe you might have already suspected, I don't have any guests today. So that's typically when our viewership or our listenership drops a little bit because everybody's more excited about the people that I bring on, my compatriots here at Lois Law Firm, than just hearing me talk for the entire time. So I thought we'd change it up a bit because one of my favorite things when I'm watching a TV show, and it doesn't happen as often these days, is a clip show, a remembrance show of what has happened in the past. Where you tune in and there's a general kind of understanding of where you are currently, but the TV shows, maybe because they're out of content, provides you with different short clips of what has happened in the show's past. And because we are halfway through the year, because it's been such an incredible year already, and with July, August, and September kind of already in the can as far as topics for the next 3 months, I thought it'd be kind of interesting to look back at our year so far at Lois Law Firm and specifically the Third Fridays podcast. So if anybody missed any of them, right, you can get your little snippets and teasers here and then go back to listen to them, if you need something to listen to on the beach or on a long road trip. So in January, we actually celebrated 100 episodes of this podcast. It's a crazy number, something that I did not contemplate when this podcast first started in December of 2016. The support of the firm and our clients, our prospective clients who listen, even my adversaries who message me every now and then, giving me a little ribbing or teasing or telling me that I'm too slanted in favor of the defense. Hey, guilty as charged, right? This is what I've been doing for quite some time now. It's always nice to look back on where we were when we started. And given that we're doing where we were over the past year, January, was a really big event for the podcast. And so what we did was we brought several leadership level attorneys in our firm to talk about where they were in December of 2016 when the podcast first started. So the podcast first started really because of an idea that we wanted to let our clients in on those scholarly conversations that we have about nuances in the law, right? So if you were a loyal listener and you hear the intro into the podcast, we talk about kind of like this 201 level discussion of what's going on in our industry, the ever-changing industry. And so since we have those conversations on the daily, on the hour even, at the firm, we thought, what would a client think about if they were a fly on the wall, or maybe not a client? What about an adversary? What about a prospective attorney or paralegal that's looking to apply here? I think that those types of conversations generally don't get publicized because maybe there's a fear of divulging client details or preferences we have for certain judges, things like that. And the reality is that most of those conversations don't include those things. Most of the conversations between attorneys and paralegals, especially at this law firm, can't speak for others, are about those nuances in the law. How do we tweak the degree of creativity, advocacy, professionalism, and service based on what is happening in the law to create and uphold the standards that our firm is about? So that fly on the wall mentality really started this process. And it came about because we didn't want to create something that involved too much additional work, at least from the attorneys and the paralegal side. We know that so many people behind the scenes of this podcast are doing actual work. So we have to give a shout out to our managing partner, Greg Lois, looking into the best tech equipment, probably being the most loyal listener of this podcast. Everyone behind the scenes that sets up a beautiful atmosphere for our guests to appear. So Lauren Rella, thank you. And our director of branding, John Grayson, has been a tireless worker behind the scenes, putting this together, making me sound good every time I sneeze or cough, or maybe a guest has the microphone too far away or too close. I mean, those types of things are so overlooked when you think about a podcast, but they cannot go underappreciated, unappreciated. Those are certainly things that need to happen in order for a podcast to run. And from the attorneys and paralegal side, the idea is that if you're having a fly on the wall conversation where, the client or the adversary or the prospect is the fly on the wall, you're speaking from what you already know. You're not preparing for a scholarly debate if it's just between colleagues. And so we don't really do that for this podcast. I don't sit around and create, hours and hours of content based on review. We kind of take a look at a topic and I ask a guest, hey, would you be able to kind of discuss this issue without adding to your day, right? Can you give me 20 to 30 minutes of your day just talking about what you know? And that's the beauty of what this is. And so when we brought on those leadership attorneys in January of this year, it was really a celebration of diversity in background and diversity in character, which leads to the overall makeup of this firm. We had a few people who were in workers' compensation when the podcast first started in 2016. And so their perspective on how the industry has changed from 2016 through 2026, and those 10 years, how does it shape how a client is represented? What is more important now versus before? We had people representing plaintiffs talking about, what they wanted to do with their lives, if that was the right move for their career. We thankfully know that they're on our side now, so I think that they've made the right choice. We also had some senior associates who weren't practicing at all. And I think when we talk about those types of backgrounds and experiences, it really celebrates the meritocracy here. There is an understanding that in the old law firms of the past, it always depended on seniority. It always depended on, who your dad was, which partners of the firm you talked to. And here, when we looked around the room and saw all the different backgrounds, all the different levels of experience, to be in a leadership position based on the merits of your craft, the merits of your skill, the adequacy and perfection of your work is something truly to behold. And so when we look at that compared to where we are today, it was a kind of a watershed moment to kind of celebrate everybody in the firm that perhaps doesn't have their backgrounds spoken of. And so that is a very important distinction. Now, from January to February, we went back into our bread and butter. We talked about potential regulatory changes in the Workers' Compensation Board. And who better to talk about that than one of the true geniuses of our industry, Noah Pollack, to talk about this proposed change that would affect the employer's right to cross-examine opposition experts. Now, there had been an old regulation that was rarely used, applied, or even referenced when I first started working in this industry, and that's Regulation 300.10c, that basically permits an employer or carrier to request cross-examination of any medical expert whose report is in the file for any reason, as long as that request is made timely. And I started at a different firm, long ago, and I learned how to do this job or this to defend clients really by watching other attorneys handle hearings in court. When the world didn't have virtual or remote capability at that time, you would go to court and watch cases. I would ask more experienced attorneys how this happened. I would ask more experienced judges, even claimant side attorneys, like how do you approach this type of scenario? And the mistake in that approach, while it was exciting, was that I would learn how to do things based on how it was done and not how it should have been done. And so at the time, I didn't really learn Regulation 300.10c, that I could take advantage of the fact that a New York claimant is raking their employer and carrier over the coals with unlimited medical treatment, that I could request cross-examination of any doctor whose report is in the file for any reason. I was under the impression that you needed contrary medical evidence, that you needed an IME. And this came to light in an appellate decision and a court of appeals decision years ago in a case called Lazuli, where the court of appeals ruled that the employer, the carrier, have that right embodied in the regulation. Now, the interesting thing about Lazuli is that it didn't change the law by any means. It just gave practitioners recent case law to reference that would make people understand that this right is in place. And that's a very, very important tool for the defense team, because you don't have to always obtain an IME if you don't believe the opinions of the treating providers. And so still to this day, we have that option if an IME can't be scheduled. And this could occur for a variety of reasons, right? What if the IME expert isn't available in the time frame provided by the judge? What if the IME expert that you want is out of the location where the claimant lives? What if the IME expert does have those availability, and then the day before the exam, they have a medical emergency, or for whatever reason, the exam doesn't go forward? Those types of things in the past have kind of doomed carriers and employers in litigating several different types of issues. But protecting the litigation position by virtue of cross-examining medical experts has been a very, very worthy tool. And because of this, the Workers' Compensation Board has assuredly directed more depositions over the past few years than they probably have ever before in any 3, 4, 5-year period, because of exactly what I said, how I learned, right? Learning about how things were done as opposed to how things should have been done. And because depositions may not have been set for certain issues without an IME, now depositions are being set properly and allowing employers and carriers to raise labor market attachment as a defense earlier, allowing for procession of litigation issues without obtaining an IME, which is certainly a heavy cost on insurance companies. And this has now come to a head because now the Workers' Compensation Board is planning to propose regulation, or not planning to propose, they have proposed regulation that a law judge will now have discretion to deny that request. And so what Noah and I talked about in February was very interesting, because if you think about workers' compensation in New York as a whole, one of the crooked schemes that we deal with are the consistent total disability reports, the consistent surgery request reports from treating experts, treating providers that don't really have the claimant's interest at heart all the time. They issue the same reports, they copy and paste, maybe they're even filled out by staff, and all of a sudden, a claimant has been out on total disability for 2 months, 3 months, 4 months for what could be a minor injury. And if the Workers' Compensation Board is looking for a way to change its administrative process, one of the things that they do is use their administrative power as an agency to amend regulations that would then be different than what case law precedent is from the Court of Appeals or Appellate Division, so that they can now exert their authority in the way that they want. And to be clear, as a defense attorney, I'm not saying that this is inherently wrong. The Workers' Compensation Board actually has the most knowledge about how the system should work, and therefore should have the discretion to amend regulations to have its stakeholders be served and serve employers and claimants in the best way possible. Here, it was seemingly a very, very silent issue until the regulation would give the discretion to the law judge. And so Noah and I talked about, why this is happening, what this result could be like, and what we're doing about it. We've talked about in the past that, the mobilization of our side can be a very, very enlightening thing. It goes back years into these RICO conversations, these RICO investigations that we have now about crooked doctors, crooked schemes, pay for play, firm runners, financial lenders to really hurt claimants in the long run, and how these entities are now being prosecuted as defendants in New York Civil Court. And the idea here is that we had recommended that our mobilization could be used to issue comments, to request no change in the regulation. And so that was a very important discussion topic that we talked about in February, because if that changes, if the law judges will now have a discretionary power to deny cross-examination, coupled with the fact that we just had new laws or regulations go into effect about the providers in New York, right? So if you've been listening or paying attention to Governor Hochul's latest announcements, she has authorized every medical provider in the state of New York to treat workers' compensation claimants. And so that is on its face a good thing for the claimant who cannot find medical care. The one thing I would say about that is, find me a New York workers' compensation claimant that doesn't have access to a medical doctor. I haven't seen one yet. I don't know that that's really occurring, and I think it's more window dressing on a clean window, if you ask me. But before I go off topic into that little soapbox, essentially, if you have a discretionary power given to a law judge for a regulatory and confirmed right of an employer or carrier or a party of interest, we know that's going to be litigated. And so if you are the employer or the carrier that it would seriously be affected by this type of regulation, and to me, that's everybody, we need to be prepared. We need to be prepared to use our appeal power. We need to be prepared to go to the appellate division if necessary in certain types of cases, and also to push back on regulatory reform that isn't really accomplishing its intended effect. So that was February. And perhaps I spent a lot of time talking about February because in March, we didn't have an episode for the first month in a very, very long time, with good reason. I hope my wife does not mind us sharing a little bit of personal detail here, but my wife and I welcomed our first child in the month of March, and there was some thought that I could interview my newborn child and record it for y'all to listen. But I realized that, maybe that wouldn't provide any real context or content for workers' compensation defense in New York. So I chose not to interview my newborn son. We didn't have a podcast in March. And then that brings us to April. And April in our world here at Lois Law Firm in the past few years has been defined by training on fraud. And fraud is probably the most powerful tool we have, other than perhaps litigating the compensability of a case, right? In a fraud case, we have so many different types of fraud that is being perpetrated by a claimant that we can use to gain leverage in a case and obtain a trial judgment with a penalty attached to it for future and retroactive indemnity. And we also know that in April, sometimes we like to have a little fun here. So there was the typical notion of an April Fool's joke when we talked about our podcast episode. So I had along one of our, rising young talents in Alexa Cintron here, and we actually cultivated 6 scenarios between us. And we said, based on the premise, is this something that actually happened or is it an April Fool's joke? And in this industry that we currently practice, sometimes real cases, real fact patterns, real scenarios don't seem real. They don't seem true. They don't seem accurate because of how ridiculous they may sound. And so it was actually very fun to kind of make up things or actually draw upon our own experience as practitioners in the industry to say, did this happen or did this not? And to kind of tie it in with fraud, one of the scenarios we talked about was a fact pattern where the claimant very egregiously violated any kind of common sense fraud notion that we had. But we termed it as an April Fool's joke because the fraud statute actually hasn't been around forever. It has only been, if comparative to how long the workers' compensation system has been around, fraud hasn't been around along with it. And if we think about how tough it is to defend workers' compensation claims in New York today, and it is incredibly tough, given all the advantages given to claimants and employees, think about a world where we could not argue that they outright lied under oath, that they outright failed to disclose a prior injury to a similar body part, that they were working while collecting compensation awards. In fact, if you did prove that, you would only be able to argue that maybe your expert was more credible because they had more information. But to not have that potential tool to say that this claimant has so violated our norms of the system that they should not be entitled to indemnity for the rest of the claim, I can't imagine how many claims went on with continuing fraud before the statute came about. So that was a very good discussion in and of itself. And Alexa and I, of course, had a little fun with that. But probably the most exciting episode we had was last month's. And I did promise you that I would recap last month's episode, obviously, but we're waiting till the end, going in chronological order. And last month in May, we had two very special guests. It was Steve McClendon, and it also was Avery Dover. And those two individuals were the inaugural winners of the 2026 Lois Law Firm mock trial program. And I know from some of my friends and family that listen to this podcast that the mock trial episodes have been the most fun. I've actually heard more recently that some clients and adversaries actually listen to the mock trial podcast because it's something different. It's something fresh than waxing poetic about deposition regulations, right? I mean, only nerds like me actually enjoy deposition regulations, but the idea of bringing a mock trial program to the forefront is very, very near and dear to my heart. And we had always had a program that lasted 4 to 5 months continuously, that we were always trying to tweak and get better. So if you have listened to the mock trial episodes, you'd know that in the finals of the mock trial, it would be a podcast competition where you'd be doing some type of oral argument, or maybe you were playing the role of a board panel member or a trial judge that was deciding an oral argument on the fly. And the interesting thing about that is this year, we kept all the good stuff and extended it to a full year, breaking it down into multiple seasons. And we knew that, if you entered the firm in the middle of the year or in the middle of the mock trial program or after the mock trial program had even started, you were at a disadvantage. You didn't get the opportunity of trying to win the cash prizes or meet teammates that, don't work in the office at the same day as you. And having this program come from a place where we could do it every month, and really get the whole firm involved was something old, something new, something borrowed, something blue, right? The idea is everybody on the firm is engaged for just a couple of hours on a third Friday. And so we had Steve and Avery on to really discuss how their approaches changed based on the new format. Very, very interesting conversation between us because Steve is one of our longest tenured attorneys here, a senior associate at the firm, has been through mock trial programs before, and his perspective in winning it for the attorneys in season 1 of 2026 was assuredly different than Avery's, who is still in his first calendar year at Lois Law Firm. So from Avery's perspective, not having a single backdrop of experience the year prior in either our mock trial program or even workers' compensation defense at all, versus Steve's having all the experience, right? A very, very good debate as to what works, what doesn't, what recommendations they would have. We called it a champions primer because we know that people do want to win this. The cash prizes aren't $0. We know that those types of conversations are important for everybody to try and gain an upper hand. And, for our clients, when this gets posted on Friday, June 19th, we will actually be in the middle of an in-person mock trial competition, as we are every month for the in-season months. And for the first time ever, we're going to have clients and stakeholders arrive in our headquarters office and watch. And that is an incredible, incredible thing. Something, again, I never imagined could have happened when we first dreamt of this mock trial program years and years ago. As the chair of this little shindig, it is a delight that clients would be this excited to see us practice our craft. So we're not using it really to compete with each other. We're sharpening our tools together, and to have clients see how the sausage is made, how the formulas are put into practice, into application, is amazing and exciting. And I think that's a perfect end to this month's episode. So if you didn't like this clip show, I don't know what to tell you. It's been 30 minutes and you've kind of spent that time with me, so I'm going to thank you anyway. But we do have a great set of topics lining up for the next 3 months. In July, we're going to talk about durational credits, Section 15.3W, and their application strategy in litigating claims with the loss of wage earning capacity. In August, we'll have season 2 winners of the mock trial program and see if they have any different perspectives or if they heard what Stephen Avery talked about last month and put them into play. And then in September, it's going to be yet another birthday for Lois Law Firm. We're going to talk about the state of the firm at that time as we celebrate 11 years at this place. So this is the point where I'd sign off and really reference our guests, but it's just me. So once again, my name is Christian Cison, and thank you for listening. This is here for me to remind you to defend from day one.